Okay, good afternoon. Today is Monday, June 17th, 2024, and we are talking about Section 29 in New York workers' compensation cases. And if you're joining me today, I hope it is to learn a little bit more about how we use our Section 29 power to get the best outcomes and the best recoveries for our clients and insureds and self-insureds in New York workers' compensation actions. Good afternoon. My name is Greg Lois, and if you're with me here today, it's to learn a little bit more about this topic. So thanks for joining me today on a beautiful summer Monday. I hope everybody had a great Father's Day weekend. The weather here was absolutely unbelievable this weekend. It was like perfect early summer, cool in the morning, warming up in the afternoon, just like a great Father's Day weekend. So for everybody out there that was celebrating, I hope you had a great weekend and a wonderful experience. We're going to dive in today into Section 29, and this is like a place where it's so fun for me to start to like unravel some of the confusion and mystery around Section 29 consent, reimbursement, and subrogation issues in the state of New York. This is a completely and totally live webinar. I see we have a number of people who have joined in live. If you joined in live, I'm hoping it's because you want to ask me questions as we proceed. Please do so. There's a question box in this GoToWebinar meeting. Type your questions in there. I will answer your questions at the very end. I will say your name so you know I'm answering your question, and then I will do my best to answer your question to the fullest extent of my ability. What a fun opportunity to try to stump me on Section 29 Arcana. So let's talk a little bit about what is Section 29 New York. What we're really talking about is a section of the New York Workers' Compensation Statute that allows for reimbursement actions or subrogation for the carriers or employers who have paid money in a New York workers' compensation case where the claimant also has a civil action and they've made a recovery from an actual tortfeasor. So the situation would be your own employee, maybe they got in a motor vehicle accident or they had a slip and fall on someone else's property or involving another vehicle. They bring a workers' compensation claim against you for the results of their injuries and their impact on their wage earning ability, but they also bring a civil action against someone else. Or maybe they haven't brought the civil action and you're going to bring it standing in their shoes. You're going to subrogate that action and bring it on their behalf. That's positive for you. That's a real positive for you as the employer because it means you're going to get some reimbursement from the actual tortfeasor. Now, this is specifically allowed under Section 29 of the New York Workers' Compensation Law, which gives you this right as either the carrier or the employer. And again, this is powerful to us because it helps us save money. It helps us get our money reimbursed from the actual tortfeasor. The actual person who actually harmed your employee has to reimburse you. And what happens if your employee goes and takes money from that other party without reimbursing you? What happens to you, the employer? Good news. A, you have a statutory right to that reimbursement, and if they don't ask for your permission before they do it, you don't have to pay them any workers' compensation benefits into the future. So this is a powerful tool. Section 29 actually requires that we give written approval to the claimant for the proceeds of any civil action or reimbursement they obtain from any third party. The burden is on them to get our consent, so that means we don't have to do anything to perfect this right. This is self-executing. In other words, you don't have to be filing documents, you don't have to be actively pursuing or monitoring their case. They have an active duty when they resolve or get close to resolving their civil action to bring you into their case and make sure that they reimburse you appropriately, right? Now, if they don't get our consent before settling that civil action or third-party action, they waive their future workers' comp benefits. So that's really the penalty to them. That's really the thing that you're holding over them, and that's really your power in this situation. Now, they do have some remedies. There's some things they can do if we don't give our consent to their settlement. And I'm going to talk about that. I'm going to talk about how worried you should be if they bring an action against you saying, hey, this carrier did not bring their consent, okay? So how rigid is the requirement that they ask for our approval? Well, the answer is the claimant has to do this. And I'm going to tell you, this is a very rigid and a very often applied statute. In other words, where the claimant says, I don't really need your consent, I can work around you. Absolutely not. The statute does not allow for it, nor does the case law. Because the case law says that consent is required whenever settlement is less than the benefits provided, any settlement really requires our consent, even cases where we have denied the workers' compensation case's compensability. In other words, in the workers' compensation case, I've said, you know what, this isn't a workers' comp case. You're not my employee. You have no rights against me. This case should be denied and disputed. I still retain, even in that situation, the right to be consulted before they settle a civil action or a third-party action, and they still have to get my approval of that. So that's a really powerful right that's almost impossible for them to destroy. Now, what about where the claimant goes and gets a settlement that's for 100% of the maximum policy limits that was available in that civil action? Do they still have to ask for my approval? The answer is yes. And I've had adversaries come forward to me and go, Greg, it's a $3 million policy, and I got $3 million, so I don't really need your consent. I don't really need to hear from you. I said, yes, you absolutely do, because that might not be the maximum that they could have received, and they could have proceeded directly against the tortfeasor. In other words, beyond the exposure limits of their insurance carrier. How about cases where we haven't paid anything, haven't paid a cent in the workers' compensation case? And there might be reasons for that. We might have disputed or denied the case, or maybe they just never brought a work comp case. They went directly into a civil action. Is my consent still required? And the answer is absolutely yes in those circumstances. All right, how about cases where there is a no-fault carve-out? Remember, under Section 5105 of the New York insurance law, the first $50,000 of considered first-party benefits in a motor vehicle case may be carved out against a civil action or for recovery in a civil action from a New York workers' compensation payment. Consent still required even where the amount they recover is less than the carve-out? Again, the answer is going to be absolutely yes, because it's going to affect our downstream rights, as I'll explain a little bit further in this presentation. All right, what is the power of this consent agreement and how powerful is it? And my answer is going to be it's extremely powerful right that you yield. Other jurisdictions might ask you to perfect your right to reimbursement. Not in New York. In New York, the burden is on the plaintiff in the civil action, and the burden is that if they have a civil action and there's been a workers' comp claim anywhere, ever, maybe even potentially, they have to take our rights into consideration and take care of us, meaning reimburse us or reduce our workers' compensation exposure. So that's a super powerful argument. It's one of the most useful tools we have available as a carrier or a self-insured employer to make sure that we get the most favorable settlement we can. We get to call the shots, not claimant's attorney. We can memorialize how our reimbursement is calculated, and we can explain specifically how we're going to get that paid back. And we have a lot of latitude in how we draft these agreements. I draft consent agreements all the time. And a consent agreement is just us saying to opposing counsel, hey, we know you've recovered in a civil action. Here's how we're going to get our reimbursement rights of our lien. And here's how we're going to pay our portion of benefits going forward. And it's going to obviously be reduced by the amount of that civil action. So absolutely, we can put that in writing, even though the statute has some say and some case law has some say into that, but we can put into writing and the parties can stipulate or agree to this any way we want. We can agree how future rights are going to be applied and resolved. And this applies to both the indemnity benefits that we may have to pay into the future, as well as medical benefits that we are paying right now. The importance of getting the consent right is very important, and it's very challenging sometimes. So we, again, have this right to either grant or withhold our consent to a civil action. And just to talk about when I would withhold my consent, I would withhold my consent in circumstances where, for example, the recovery in the civil action is so small, it's ridiculous, or the plaintiff's attorney didn't do their job and maybe get a significant recovery. I would be challenging that. I would be pushing against that. I'd be saying, no, I'm not going to give you my consent. You didn't do what you're supposed to do. You're not recovering enough. So you do have this powerful consent opportunity. But then when you write that consent, and I always argue these should be written. Now, you're going to be able to find some case law out there that's going to say a consent can be verbal. Never ever do a verbal consent. Let's do one in writing. Let's make sure we get it right. The first reason that we want to get that consent right is because if you write a vague one or misleading or confusing one, or you leave stuff out, ambiguities are going to be construed in favor of the claimant. In other words, if you leave something out, if you forget to talk about your future reimbursement rate and how that's going to be calculated, well, that's going to be then calculated in the way most favorable to the claimant, and you don't want that to happen. Next, if you don't reserve your future rights, you're waiving those rights. So make sure that your consent letter contemplates that. Sometimes it's possible to pay more than your fair share, to have fresh money coming into the case, to have to be really more exposed than you need to be. And so you got to be thoughtful about that when you're drafting your consent. I always want to navigate what I am getting reimbursement against and versus what I'm not getting reimbursement against, particularly in a motor vehicle accident case. Remember, New York has got this weird first-party rule, first-party benefit rule, I should say, where the first $50,000 are considered in lieu of first-party benefits, and they have interesting ways of calculating that. It's so many hundreds of dollars per week over so many years. It's 3 years. And so you really need to be thoughtful about how you're going to be calculating your benefit in a motor vehicle accident case to make sure you maximize your reimbursement. Any rights that you're waiving, think about how often you're asked to compromise your reimbursement lien. And you'll have a claimant who says, look, your reimbursement lien right now is $400,000, but if you waive $200,000 of that and only accept $200,000 now, we'll waive or give you a dollar for dollar offset into the future. So you're going to make a deal like that. Be clear about that. Any right that you're waiving, any right of reimbursement or future offset that you're waiving, let's be very specific about how we are going to get that compensated to us or returned to us so that there's no ambiguity. Because again, ambiguities are going to be construed against us and are going to be construed favorably to the claimant. Now, I'm going to talk just briefly about a relatively recent case, just because it's only about 10 or so years old. It's called Williams versus Lloyd Gunther. It's a third department decision. It's from 2014. And it really says something very interesting. It says our rights to credit or offset, again, our right to either reimbursement, getting our money back right now, or our right to reduce future payments. That's what an offset is. That right to credit now or pay back now or offset in the future begins whenever we say it does. So whenever the parties agree in a consent agreement, that's the time and date that we can start reducing our payments going forward. Wow, that's amazingly powerful. In fact, that's one of the most powerful rights we have under the New York workers' compensation law as an employer or a carrier. That means we can apply these rights to either reimbursement or reduction of payment as of the date of issuance of consent. So in other words, the party comes to me, I'm still paying a case under a carrier continued payment, CCP, or I'm paying a case under an SLU or a PPD less commonly. And I'm paying them going forward, and I owe this money. I'm still paying on a monthly basis, and I'm still paying for medical treatment. The other party goes and settles a civil action, comes to me and says, will you give your consent to the civil action? I can say to them in my consent letter, sure, I'll consent to resolving your civil action, but you have to agree that my rights to reimbursement and my right to future offset or credit begin now. And that's beginning as of the date I sign the consent letter, not the date that some judge approves it or when it gets filed in court. That's a really powerful right because it means we don't have to wait for anything. We don't have to wait for court approval. The parties can simply agree to this between them. It also means that the amount of money could change, right? If I'm under an obligation, under a court order in the workers' compensation court to continue making payments, that means that every week we're going to have to keep recalculating how much money we're due to be returned. But actually, if I put in my consent letter that under the Williams versus Lloyd Gunther elevator service case, my rights begin now, that means I can start taking my reductions immediately. So it's very useful in that context and very useful in the global settlement context. That's the context where I am going to maybe waive some rights in my workers' compensation settlement, reimbursement action, and I'm going to settle a civil action at the same time. We can halt the benefits. We don't need a Section 32. I do not need a judge to weigh in. That's a super powerful right, and it's hidden away inside Section 29. So not a lot of counsel or workers' comp defense counsel are always even aware that we have that opportunity. Now, let's talk about the Kelly, Burns, and Bissell cases. This is where people get lost in the woods a little bit, and it's really not that complicated. Kelly simply says that or sets forward the calculation for how much money we can be reimbursed and how we calculate a future offset percentage, right? And it really is just whatever is the recovery in the civil action is going to be reduced by a cost of litigation percentage, and then we're going to play that same cost of litigation percentage to reduce the amount of our reimbursement in our workers' compensation case. That's it, really quite straightforward in terms of Kelly. Burns addresses how that applies to future payments, and it really just says that future and medical indemnity benefits are going to be paid at this reduced rate, and that rate is generally the cost of litigation percentage, the same one that you calculated under Kelly. So again, not confusing, but the fact that there's two different cases that had to say that, okay, welcome to New York, they like to make things a little more confusing. Now, Bissell is simply a hybrid of Kelly and Burns, and it just says, hey, look, future medical might be speculative, just like a future payment of permanent partial disability might be speculative. And for that reason, as you pay medical into the future, you're going to continue to pay it at a cost of litigation percentage going forward into the future. Now, the consent that we're going to reach is consensual, right? Like it's the parties negotiating between them. So this should be clearly laid out in the consent agreement. It should address, here's my Kelly cost of litigation percentage. Here's what I'm due as reimbursement now. The consent agreement should always say, I think we have some speculative exposure into the future, and so we're gonna have to apply Burns to that, meaning I'm gonna pay that exposure into the future at a cost of litigation percentage until it's exhausted, and list out when it's gonna be exhausted. And finally, it should also list out if there's future medical, what rate that future medical is gonna be paid out, and whether that's speculative or not. So we want that to be very clear. What is the cost of litigation based on? What is it? What did we take into consideration? We came up with that cost of litigation. Please, that should always be laid out in your consent letter. How do future offset rights apply? When do they begin? Again, that should be in your consent letter. How is the future offset calculated? And what is going to be the net amount of money moving now to the claimant? Again, that should be in the consent letter. When I write consent letters, just as an aside, best practice, they're anywhere between 2 pages in a very simple case up to about 6 or 7 pages in a very complicated case, because I am not leaving any of this to chance. Remember, ambiguity is going to be deemed in favor of the claimant, so you want to be as specific as you possibly can. Finally, you need to address how future medical treatment is going to be addressed and calculated, how future carrier continued payment is going to be reduced, and how that's going to be calculated. You want to do all this in advance. You want to put this in your consent letter so that you're not stuck fighting about this 3, 4, 5 years from now when those payments are finally coming to an end. Now, another question we get when we're talking about whether or not Burns reduction should be applied. Remember that Burns required that we pay our share of litigation costs moving forward. In other words, whatever the litigation cost percentage is, let's say it's 28%. 32%, sometimes it's as high as 35%. It means that going forward, our obligation to make those continuing payments is going to be reduced by that cost of litigation. Now, that can result in us having to pay more than maybe we necessarily should, or getting less than our potential reimbursement. And there are a few ways to get around it. First, we can specify exactly when the Burns credit will end and when our obligation is satisfied. So we're going to want to list out, here's exactly how much the claimant received in the civil action, here's exactly how much their attorney's fees was, and here's exactly when our exposure period ends. And we'll calculate that out and put that in there. In some instances, the claimant will actually agree to waive future Burns rights. Okay, this is uncommon, but it can sometimes happen in very small recovery scenarios. And sometimes we'll waive our current lien in order to satisfy our future Burns obligation, that future obligation to pay into the future, again, at a reduced rate. We can get rid of that by saying, hey, right now, we're entitled to $200,000 in reimbursement, but we're going to waive that reimbursement, and you agree that in the future, we'll have considered satisfied our Burns obligation, and we will no longer have to make those payments into the future. So that's an opportunity that we can make as well. Now, however you resolve this or however you negotiate your burns obligation into the future, again, let's be specific in that consent agreement. I always, in my consent agreements, put a couple paragraphs about this. I want to make sure this is extremely clear. Sometimes I'll put in my consent agreements that there's going to be a dollar for dollar offset. What I'm really saying here is here's how my burns rights will pay out into the future. Again, in small settlements, if you're asked to compromise a lien, I will often use that as an opportunity to negotiate a burns waiver, complete waiver in exchange, and try to completely eradicate my future exposure. Some other consent issues that we bump into. Now, consent might be implied if the workers' comp carrier and the carrier in the general liability claim are the exact same carrier, so just be thoughtful about that. There are some board decisions would say, hey, sorry, it's the same respondent carrier on both actions, the civil action and the workers' comp action. So in those instances, I'm sorry, it's going to be deemed that when you resolved one, you resolved the other, or you had essentially consented to it in the other case. So be mindful about that. Oral consent has been allowed. It's rare. I think it's like the worst practice ever. You should never, ever have to deal with an oral consent. So let's be thoughtful about that. Remember, consent should be done, memorialized in a specific letter. Now, can your consent include a requirement that they discontinue the third-party action? Well, the answer is absolutely yes, right? So that's possible as well. And that is a potential thing that you can put into your consent. Now, the most interesting thing is what happens if we don't consent to the civil action or the third-party settlement, right? And I want to bring this up just because this does happen, and often sometimes you'll see the third-party attorney getting so up in arms. They settled their case 2 months ago. They've reached out to the workers' comp carrier, and no one's issued a consent immediately, right? Okay, and they'll get angry, and they have some choices. There's some things they can do. Now, there might be some good reasons that we haven't consented, right, to their civil action. The first one would be, hey, our workers' comp case is like in its infancy. We don't even know what the workers' comp exposure is going to be. So I'm not going to consent to anything that waives my client rights too early, too soon. How about where I don't think third-party counsel is really, I'm going to use the word being a strong advocate or doing a great job representing their client. And so they're asking me too early in their case to consent to something. I'm saying, wait a second, how is that possible? So there are a lot of good reasons why maybe the case is not ready for consent. So what happens? Now put yourself in plaintiff's attorney's shoes. They represent a plaintiff in a civil action for a bodily injury case. It's pending in New York under a general liability policy or motor vehicle accident or whatever it is. And they're angry because the workers' comp carrier, which did pay some benefits to their client, is not consenting to whatever cannot consent to whatever settlement that they've reached in that civil action. So the law anticipates this and has set up two remedies for the plaintiff's attorney or the claimant in this scenario. The first one is they can go and seek a compromise order, even though we're objecting to it, even though we're saying, Judge, this is not ready for consent. We don't have enough information. The workers' comp case is not ready. We don't know, Judge. We can't consent just yet, right? So there is an opportunity for them to go seek a compromise order in the Supreme Court case, the civil action. And the other thing they can do is they can seek our consent on a nunc-pro-tunc, NPT motion. Nunc-pro-tunc means now for then. In other words, they can go and accept that money in their civil action, then turn around to us and go, yeah, well, we didn't ask for your consent, but reasons, and we're going to file a now for then motion, and we're going to have the judge retroactively approve that now for then motion. Okay, it's an either or, by the way. These two approaches, either seeking that compromise order, which gets the judge involved, or doing a nunc-pro-tunc. I've also had situations, particularly where I'm representing a workers' comp carrier and there's a motor vehicle accident case, where the judge has told them to actually go even file another civil action seeking that compromise order. I've had judges actually say that here in the motor vehicle part, we don't have jurisdiction over this, go file another action. I've even seen those things, okay? So if we don't consent, they have this choice to go do one of these two things. Let's talk about the first one, the compromise order. I call these cram down motions because they're trying to cram down my lien. They're trying to cram down the amount of my reimbursement, okay? And they have very specific requirements for this within the terms of the statute. And they've got to file a very specific document. And they have to include an attorney affidavit and even a physician affidavit. So a lot of these cram down motions that I see are on their face invalid because they don't contain what they're supposed to contain. The contents of the attorney and physician affidavits are specifically laid out in the statute. If they don't say those magic words, then the action should be thrown out as defective by the Supreme Court judge or the civil judge that's hearing them. We need to get notice of this motion, and we have an opportunity to oppose it. We'll oppose it generally by way of affidavit, and in my experience, we'll go to court and we'll make some oral arguments. Now, a lot of times the documents or affidavits that are submitted in furtherance of this cram down motion are not exactly what I would call complete, usually lacking the physician affidavit. In my experience, a lot of these Supreme Court judges will simply say, all right, well, you did substantial compliance, you got close enough, it's good enough. Okay, so that's number one. That's the first way that these get before the judge. And actually, these are a little rare. The more common way, the more common thing that we defend is what's called a nunc pro tunc motion. And nunc pro tunc is just Latin words, okay, which just mean now for then. These now for then motions essentially say, hey, I already accepted the settlement, the case is over, I've taken these monies in, I want to disperse them to my client, but I need this consent, and whoopsie-doo, I forgot to get the consent, or I didn't get the consent, or I felt like I didn't need the consent. That's more often. They'll say, look, I got policy limits in my action, I didn't need their consent, I just went and took it, all right? In a nunc pro tunc motion or now for then motion, they have to come before the court within 3 months of that settlement and show why they didn't do or didn't get our approval in advance. Again, they still have to meet that same criteria as a compromise order in showing why the judge should agree with them. They have to talk about the reasonableness of the settlement. In other words, they have to say, look, my settlement was really big. It was really high. It was a very good settlement. It was a very fair settlement. They have to say, hey, there's not my fault that I didn't get their compromise, and that there isn't any prejudice to the carrier in you, judge, forcing them to compromise. Now, in my experience in case law is that when they bring these kinds of nunc pro tunc motions or compromise orders, even when they do this, and even when they win, it's very rare. I mean, I've been at this 23 years and we never lost one as far as I know. Even when if they did win, the only thing the judge can do, the only remedy the judge can actually craft is to give them whatever their rights would have been under Section 29 anyway. In other words, they still would have to show that they're giving us our full reimbursement, and the judge still has to apply Kelly, Burns, and Bissell to make sure we get back all of our money. So even where adversary threatens a compromise order or a nunc pro tunc motion, really you're not in a dangerous position. I mean, put in pro forma opposition, show up at the hearing, make your basic argument, and even if you lose, the judge goes, yes, I'm going to order this settlement as fair and just, and I'm going to order it now for then. That's fine. The judge still can't reduce your order or your reimbursement right or compromise your right to a future credit. That's outside of the judicial power. So, third-party consent, some best practices, things that we've learned over the last 20 years. First, I don't find it useful to really talk about my consent to a third-party settlement unless I've already looked at their proposed closing statement. I want to get an idea of what are your fees, what are your costs, what's the total recovery, and I really want to see it. I don't want to hear someone's version of what they're getting. We need to know our most current lien total. If you're familiar with my office, you know we're always asking you for that. We're going to lay out the Kelly calculation. That's that cost of litigation calculation. And that calculation is going to be so important because it's going to lay out what we're going to get right now back from the claimant and what we're going to be exposed for in the future. I also want to calculate the net to the claimant and get all the parties to agree what the net to the claimant is now and what that future offset's going to be. I want to talk about what are the future rights and credit rights that I have and how they're going to be applied and when they want to begin. And of course, I'm going to want them to begin as soon as I sign that consent letter. Now, not then, not speculatively, not when they get their check, but now, because that helps us and impacts our workers' comp exposure now. If there's a motor vehicle case, I'm going to want to address the no-fault law, which says that there might be a carve out for that first $50,000 in lieu of first party benefits. I'm going to want to address that. And I'm going to want to always include the instructions for reimbursement, because remember, when we're successful at this, opposing counsel, plaintiff's attorney, is going to write us a check. It's the greatest moment in the world when I can hand to my insurance company or my self-insured employer and I say, here's a check for $100,000. Here's your money back, right? That's my goal. I feel so good when I get to do those things. We want to reserve all of our rights. I want to make sure that our future offset and credit rights under Burns are going to be addressed. I want to make sure that there's a statement in there that says the final closing statement, because remember, the plaintiff's attorney in the civil action can't get a closing statement until everything's dispersed, right? Then they have to go back into court and file that. I want to make sure that they provide a copy of that to me within 60 days. And I always want to include what I call a contingent revocation. What's a contingent revocation? It just means, hey, if anything changes since we last signed this consent letter, this whole thing is null and void, and we come back and do it over again. And the reason I do that is because I've had cases that they arbed at $3.9 million. Or they mediated at 3.9. And opposing counsel, the plaintiff's counsel in the civil action comes to me and goes, Greg, it's going to be 3.9. I go, all right, I'm going to prepare some consent letters. Thank you for that information. I'm going to start doing my calculations. Tell me what your cost of litigation is. Tell me what your fees were, what your costs were. I'm going to do my calculations, start to figure this out for my client. A month later, they come back to me and go, oh, good news. It's actually $3.95 billion, Greg. All right, well, that means I need to recalculate the entire consent. And it means that original consent I gave you, that's null and void. Throw that away. That's not valid. It's been revoked. So you want to make sure that you keep that in there. All right, I'm hoping that this conversation, this has been 30 minutes. It's been a lot of stuff. It's kind of fun. I really like talking about consent agreements and getting money back from my clients. I hope this triggered off some great questions. So let me come over here and see what kind of questions we have going. All right. All right, so far I got one. So if you haven't sent me a question yet, please do, because I don't want Lindsay to be the only one. So Lindsay M gives me a question, Greg. I have a case where I've spoken with a third-party carrier, and they are wanting to tender the limits. However, the attorney is pursuing suit against the motor vehicle carrier instead of accepting the limits. Is the attorney required to tell me why they're pursuing suit instead? Also, if this suit ends up being frivolous or pointless, am I still required to pay our share of the portion of the attorney's fees and costs? All right, so I got a great answer for you. And it's so fun when I can give you such a quick answer that's the right answer, right? So the answer is attorneys' costs of litigation and their fees are only going to be based on what they recover. So I would get their statement of costs and fees right now based on what they've already recovered. And they want to go off on this adventure and try to bring in a different carrier and try to get even more money. That's great. But any amount of time, effort, blood, treasure that they expend in securing this other settlement that doesn't work out should not be costed or taxed against your first recovery, right? Because that's a waste. So the answer is you could do a consent right now for this first settlement saying it's contingent on the second one. You could wait for the second matter to resolve and see if they can get any money at all from that second carrier. But in general, no. If they're going to go on adventures, they've already recovered money, you're ready to consent, you're ready to get your reimbursement, you can. If they want to go on adventures against another party or another carrier, that should not be costed or taxed against your reimbursement right in the first matter. So the answer is no. The answer, you only should pay, your cost of litigation should only be based on what they've won, and the cost of litigation should be aligned to what they actually won in that civil action against that third party tortfeasor. So Lindsay, I hope that answer is helpful to you going forward. All right. Okay, Lindsay says, Greg, clarification. It's all from the same carrier. The carrier is unsure why they won't accept the policy limits and want to pursue a different suit instead. All right, so the answer is, this is a little bit different. So these aren't not two different policies. It's really one policy, one insured, but they're going to go and try to secure beyond the policy limits. So it sounds like the carrier did what it had to do. It realized, wow, this is a really bad loss. We're going to tender our limits. And that's what they did early. And now this insured might be left without coverage for that next layer. Hopefully they have excess insurance or layers of insurance that they can go after. But it is within the right of the plaintiff to say, hey, that's great. Thank you for offering me this $3 million. But really my loss is $18 million. I'm going to go after you personally and go into any or pierce any other layers of coverage you have. In that instance, again, if they're successful against those layers, that's how I would calculate the attorney's fees. So I'm hoping that's helpful for you, Lindsay. All right, at this time, I'm not seeing any other questions. It's been a couple minutes since I put up the question list. I hope this webinar was useful for you. Please, if you have any questions about consent issues, reimbursement issues, Kelly, Burns, how this stuff is calculated, please always feel free to reach out to my office. Our firm policy at this point is to always handle these actions under the pending workers' compensation action. Where that closes, we'll open up a new matter for you and go and pursue that recovery for you. Again, thank you everyone for joining us today. It was a pleasure talking about this. If you didn't have a chance to type your question in and you have one, please feel free to reach out to me. Again, if you're listening from home, either on podcasts or on our videos, please feel free to reach out to me with any questions you have. All right, everybody, I hope you have a great rest of your month. Enjoy your summer, and I'll see you next month.